So this history of this particular violation of the people's rights goes back to the Hill case from the year 2000. In Hill v. Colorado, this court upheld a state law restricting peaceful speech within 100 feet of abortion clinics. Now, what made this law restricting speech so special? Why did the Hill court uphold the law? According to Justice Thomas, Hill's abortion exceptionalism turned the First Amendment upside down. As Hill's author once explained, the First Amendment reflects a profound national commitment to the principle that the debate on public issues should be uninhibited, robust, and wide open. That principle applies with perhaps its greatest force to speech that society finds offensive or disagreeable. Yet Hill manipulated this court's First Amendment jurisprudence precisely to disfavor opponents of abortion and the right to persuade women contemplating abortion that what they were doing is wrong. Justice Thomas makes a couple of very important points. The court has used abortion as an excuse to ignore not only the First Amendment, but their oaths and duties as justices. As the author of the Hill opinion, I believe Justice Stevens wrote, the First Amendment reflects a profound national commitment to debate on public issues. Yet the Hill court, along with the district and circuit courts in this case, ignored that commitment, apparently for one reason and one reason only: to stifle debate about abortion. To be sure, this court has not uttered the phrase, "we overrule Hill." For that reason, some lower courts have felt compelled to uphold Hill-like buffer zones around abortion clinics. This case is another prime example of that trend, and one can hardly blame lower courts for misunderstanding. When we have created confusion, we are responsible for resolving that confusion, and we should have done it so here. See, in 2000, the state of Colorado passed a law intentionally restricting speech. While this may seem to be an obvious constitutional violation, the Hill court got it wrong. It was clear at the time that Hill's reasoning contradicted more than a half-century of well-established First Amendment principles. A number of us have since described the decision as an absurd, defunct, erroneous, and long discredited aberration from the rest of our First Amendment jurisprudence. However, it wasn't just the Hill court that got the First Amendment wrong, but Justice Thomas. We have long stopped applying Hill, and a majority of this court recently acknowledged that Hill distorted our First Amendment doctrine. It seems the court long ago saw a problem with their Hill precedent, specifically distorting their First Amendment doctrine. But did you notice that? Justice Thomas didn't say that Hill distorted the First Amendment, but the court's doctrines did. That arrogance did not end there. Following our repudiation in Dobbs, I do not see what is left of Hill, yet lower courts continue to feel bound by it. The court today declines an invitation to set the record straight on Hill's defunct status. I respectfully dissent. Don't get me wrong, I agree with Justice Thomas that the court should have taken the case, but not for the same reason. See, he appears to want to establish a new precedent, while I want to restore the Constitution to its rightful place as the supreme law of the land.